So I want to welcome you all and about our talk now that we kind of have given the green light, been given the green light to open. Now what do we do and what does that look like? My name is Geoff Johansing. I am the Director Manager for the Pasadena Office of Insurance Office of America. And we are focused on property and casualty and helping our clients mitigate and navigate the total cost of risk. In that bucket, 20% of what an employer spends is on insurance premiums. The balance of it is on training, is on personal protection equipment, hiring practices, and that sort of stuff. I'd like to introduce you to Cynthia Flynn. Cynthia Flynn and I have spoken together in events like this. She is the founding partner of Hackler Flynn, and she's actually my attorney. Hello, Cindy.
Hi, Geoff. I'm so glad you suggested this. This is going to be great. As Geoff mentioned, I am an attorney. Our whole firm's focus is protecting and defending business owners when it comes to employment law needs. So what that looks like is advising companies, well, since COVID, on terminations and layoffs and furloughs, and more recently, advising our clients on how to reopen as the bans start being lifted. And so, Geoff, I'm so glad you suggested this. I do have a disclaimer, since I am an attorney, to read you for Geoff and I, that content on this webinar should not be considered legal advice and is for informational purposes only. Communications made through this webinar and or participating in the webinar do not create an attorney-client relationship. Of course, we're always happy to do that afterwards. But in addition, Hackler, Flynn and Associates and IOA are not responsible for any content that you may access from third-party resources that may be accessed through or linked to this webinar. So with that, Geoff, I will turn it back over to you.
All right, and I'd like to just let you all know that are participating on this. This is an interactive conversation type of presentation. So if you have questions during the conversation, please feel free to speak out or post them in the chat.
Actually, Geoff, since you brought up Q&A, there is a special Q&A button on the bottom of your screen. It allows you to post questions, and Geoff and I can either read them out loud and have a discussion about it, or it allows us to type out the answer and send it back directly. So sometimes that's easier when we have a lot of people participating to send all the questions through that Q&A session rather than on the chat. It just allows us to keep things straight. So.
All right. This presentation is going to help you guys with regards to what you need to do. You need to take care as an employer of your employees. You need to manage your facility. You need to take care of your customers. And then you also need to take care of those people that come and visit your site. So what physical types of areas do you need to evaluate when you're looking at this post-COVID world? There's no simple answer to this. It really varies depending on the type of industry you're in. We've got clients ranging from restaurants, auto service. We've got people in the medical arena. We've got schools. So there's a vast array of industries that we serve and Cindy serves. So depending on the nature of your organization, you'll have different exposures. A medical facility, you can imagine, has a great amount of exposure if they're in the emergency room type space versus a cardiovascular firm. An employee needs to be protected. So part of when you're looking at doing an evaluation on your entity, you need to make sure that you're taking your employees' safety into account. And then again, those people that you serve. Who are your clients? Who's there on a regular basis? And the deliveries and that third-party sort of stuff. So I'd urge you, as you're doing this type of an evaluation, to take into account all those various areas. So Cindy, I'll turn it over to you with regards to the main employee areas that an employer faces regarding getting their employees back to work.
So the biggest three issues really are compliance, right? Meaning compliance with all federal, state, and local laws and regulations, including OSHA and CDC, and watching as they change quickly during these times. Screening, meaning creating an effective and legal screening process for not just your employees, but any visitors you have to your business. And safety, developing protocols for your business, for your employees and visitors. Those are the main issues. And now, even in order to reopen, you have to have a plan in place. So, a common question we've been getting, Geoff, is whether or not you should be testing your employees prior to having them enter into the workplace. This is not mandatory for you to test your employees unless it's specifically required by your local county or city. But we do recommend that all employees be trained on CDC guidelines and safety protocols to understand what's required for compliance. And CDC just issued another 39 pages last week of guidelines that they want businesses to follow. So as things continue to develop and more guidance starts to come out, we recommend not only looking at what the state is saying, but your local county, your city, and of course, CDC. A common question we've been getting is whether or not, employers should be taking the temperature, for instance, of their employees. And prior to COVID, Geoff, I would say no, absolutely not. That is considered a medical examination. And if you're not licensed, you don't want to be doing that. But the EEOC has come out in the last several weeks and said that it's okay that you can take an employee's temperature prior to, beginning a shift. But you want to be careful that you still have to comply with HIPAA and create a safe environment so that not every employee who works for a company knows whose temperature is what, and privacy information there. Yeah, and I mean the other thing that people are asking is, they have employees who just don't want to go back to work. There are specific circumstances that could have legal implications for employers. If an employee thinks that they may be ill or if they need to care for someone at home, they are likely entitled to take paid leave under the FFCRA, the Families First Coronavirus Response Act. If they don't want to go back to work, the reasoning behind that is pretty important. This area of law is developing, and we are seeing an expansion of disability claims related to underlying medical conditions where exposure to COVID-19 would be catastrophic to employees. And so anytime you have an employee who might have a disability claim or sick leave or is really concerned about going back into the workplace, if you have a restaurant or a manufacturing company, it's really important that you run it by legal counsel, whether it be me or whatever legal counsel, employment lawyer you're using, just to make sure that you're properly complying with these new expansions under the FFCRA. And then, Geoff, do you want to get into what you can do to provide a safe workplace for COVID-19?
Sure. So there's, like Cindy shared, there are a lot of different organizations, and you're looking at the federal CDC, you've got OSHA, you've got Cal OSHA. I know I'm in Pasadena, and we actually had an inspector walking through our facility last week from the city, monitoring and making sure that we were, as an organization, compliant with what's going on. So there's a guideline called the Resilience Roadmap, put out by the state of California, and you can find it. I can provide you guys with the website. But it identifies various guidelines for various types of industries. So an industry, restaurants, you could have, again, the medical. There's so many different industries, and it breaks them down. I am going to talk about a guideline for a manufacturing facility and give you examples from the 5 points that it talks about. So again, there's 5 points. The first being your work site specific plan. So you need to have a plan for each location, and it needs to be specific to that location. I've got clients that have an administrative location, and then another is a manufacturing location, and another could be a warehouse location. So all three of those need their own separate plan. And then at those plans, you also want to make sure you designate an individual to monitor and make sure that these plans are being adhered to. The next point on this guideline is topics for employee training. And Cindy brought up previously the fact that employees can self-administer their their testing for COVID. So there are CDC guidelines for an employee to determine whether or not they have signs of COVID. That's one of the things that I found very beneficial in the topics for the training. And then the third point for the guidelines is individual control measures and screening. And again, with regards to the testing of employees coming in, if you're not comfortable providing someone the thermometer and that sort of stuff, or administering that, they can self-test. That is okay, providing it is done for the company. The next point in the guideline is cleaning and disinfecting protocols for the organization or the facility. So depending on what type of facility you are, manufacturing plant, you want to make sure that you're cleaning all of the common surfaces, be it the door that people enter and exit in, work tools that are shared, hand tools that are shared, control panels, and all types of different areas that individuals are touching and coming in contact with. And then there's physical distance guidance. And there's three different areas of this. The first is engineering controls. The second is administrative control. And the third is the personal protection equipment. So engineering controls, an example of those would be plexiglass. So you have plexiglass in between workstations in a factory floor. Many of us have seen the plexiglass that they have in front of the cashiers at a checkout stand at a market. That's an example of an engineering control. Administrative control. I've got a client right now who is fortunately very busy, and to adhere to the administrative control, they have staggered their shifts. So instead of one shift, which they normally run, they're running two shifts. So they've spread out the amount of people that are in an organization. So that would be an example of an administrative control. And then personal protection equipment. We all know about what those are, the masks, the gloves, and any other equipment that you may find your employees need with regards to their interacting and working in your environment. And then a checklist to make sure that these have been addressed. And again, strongly recommend you have an individual at each location and a team from your company that can help monitor what's going on, whether or not the controls that you have are being followed, and also that you're keeping up to date. As Cindy shared recently, that OSHA came out with another set of guidelines.
We have a couple questions in the queue about taking the temperature. And yes, you absolutely want to keep that information private. You need to comply with HIPAA for taking temperatures and recording them. It doesn't necessarily mean that you have to have dedicated personnel. It just means having that plan in place and compliance. You can absolutely send them home if they have a fever. And at the rate of how contagious COVID-19 is, you really want to act in an abundance of caution, right? So as to your follow-up question, if you do have an employee who has a fever and you turn them away and you tell them to go get tested and then it comes back that they are positive for COVID-19, you certainly need to, like what Geoff was saying, have that plan in place. And what that means is, and I believe CDC currently says that if somebody is showing signs or symptoms and was working for you on the premises and they show signs and symptoms within 48 hours of being on your premises, that's when you need to communicate to your employees that there is an employee who has tested positive, and obviously you send them home or have them remain at home if somebody tests positive. You clean thoroughly according to CDC their entire workspace, and you might want to consider telling, well, I guess if the test is positive, you want to tell any customers that were within the presence of that employee within 6 feet, other employees, anyone like that. You need to let them know that somebody has tested positive for COVID-19 in your workplace. And then if they don't necessarily have a test that says they tested positive for COVID-19, they just have a fever, but you think that they're showing signs or symptoms of COVID-19, such as the cough, the sore throat, things like that, you also can notify everybody. It's not mandatory, but you can let any employee know or any customer know who's come into contact with that person that you are acting in an abundance of caution and that you think that someone may have COVID-19. And again, clean everything pursuant to CDC guidelines. So I hope that helps.
Yeah. In addition to that, you also want to make sure you're not divulging who the individual is. It's still there's privacy requirements. So do your best to not point out or make it obvious who the individual is.
Right, absolutely. You really want to keep that confidential, like on a need-to-know basis. So if the manager has to know for some reason who supervises that employee, then fine. But you don't want it to be just out in the open on who's contracted COVID. Obviously, if you're a small business and you only have 5 employees and one of them you've sent home, and you say to everyone else, like, hey, someone tested positive, you still don't want to say that person by name. Obviously, they're smart enough they can figure out who, but just keeping that information confidential. And then someone else is asking about whether or not it's okay to insert cleaning duties into pre-existing work responsibilities. So yes, absolutely. If you have a cleaning crew coming in, after every shift or, halfway through the shift, and you want them to do more cleaning based on CDC guidelines, you can absolutely increase their duties and responsibilities there. If you're paying them, they're on the clock. You should have no issue with that. And then how do you mitigate the risk of cleaning up? I'm not quite sure I understand that, but again, I would say, unless Geoff, you have some thoughts on there, follow what CDC says.
So with regards to mitigating the risk to clean up or to do these types of things, one way to mitigate risk is always to transfer to a third party. So if you were to have a janitorial service come in and manage the cleanup of your facility, maybe overnight or something of that, then it would become their responsibility. So you could mitigate it that way. But with regards to having your own employees clean up the facility or the common areas, I don't know of a way that you can mitigate the risk that way, if that answers your question.
Well, yeah, create a team responsible for workplace safety and compliance for each of the facilities. Develop an exposure response plan that addresses isolation, containment, and contact tracking procedures, stay-at-home requirements, exposure communications to affected staff. Develop written protocols for symptomatic employees according to CDC guidelines. Establish written protocols for returning to work after being symptomatic, following CDC guidelines and applicable law. You want to train your employees too. I think this is something on safety protocols based on CDC, detail cleaning procedures and procure ongoing supplies, regularly disinfect and sanitize the workplace following CDC. And what that means is, like what Geoff was saying earlier, disinfect anything that is a frequently touched area, including your doorknobs, your phones, your keyboards, your cables, bathroom faucets, bathroom doors, anything like that. You may want to adjust HVAC systems, clean filters, and increase ventilation. Implement a negative pressure environment to remove aerosol contaminants if possible. provide tissues and no-touch disposal receptacles throughout the facility at easily accessible intervals. So things like that, I think, help. Another question we are getting right now, Geoff, is what steps should we take if someone says they were exposed to someone with COVID-19 but are not showing signs or symptoms? So it depends on how close from the time that they last saw that person to 48 hours, I think, is the current window. So if somebody was exposed, let's say on Wednesday, and by as a business owner, you can choose to send anyone home that says that they were exposed to someone with COVID-19 and wait that 48-hour period to see if any symptoms show up. Go ahead.
I would like to now kind of open to Cindy with regards to now there's an executive order that Governor Newsom put out with regards to the employer being responsible for an employee who is back at work and has been found to be diagnosed by a medical practitioner with COVID. And Cindy, do you want to talk about that? Maybe we can go back and forth, but you want to lead in and talk about the executive order?
Yes, absolutely. So on May 6th, California Governor Gavin Newsom issued this executive order, and it creates a temporary workers' compensation presumption for employees diagnosed with COVID-19. The presumption is retroactive to the date of the stay-at-home order, which was March 19th, 2020, and will stay into effect for 60 days after its effective date. Therefore, it goes from March 19th, 2020 through July 5th, 2020. And under the executive order, any COVID-19 related illness shall be presumed to arise out of and in the course of employment for purposes of awarding workers' compensation if four things are satisfied, right? And so the first is that the employee tested positive for or was diagnosed with COVID-19 within 14 days after working at a day that the employee performed work for the employer, at the employer's direction and at the employer's place of business. The next thing is that the day on which the employee performs labor or services was on or after March 19th, 2020. The third thing is that the employer's place of employment was not the employee's home, so they have to be out in the workplace working for the business. And the diagnosis, as Geoff mentioned, has to be done by a physician who holds a physician license issued by the California Medical Board. And that diagnosis is confirmed by further testing within 30 days of the date of the diagnosis.
There's a lot of stuff going around with regards to I'd say reactive type of measures that are put out. So this most likely will go through the court system. So not sure where this is going to play out, but I'd say for now we need to plan on as companies, this is how it is, and to expect that this will be law.
Yeah, and I think Geoff's right. Like, we're going to see a lot of litigation come with employment law issues, with workers' comp issues. Anytime the employment rate goes up, we see an increase in wage and hour violations, or not necessarily wage and hour violations, but alleged wage and hour violations, and an increase in workers' comp. The workers' comp presumption, I just want to make clear, this is a rebuttable presumption, so it's not an absolute presumption. So, but either way, what we're suggesting right now, and Geoff, tell me if you agree, is if someone comes into the workplace diagnosed with COVID-19 and somebody else gets it, just give them workers' comp paperwork and let your carrier figure it out.
Cindy, are there any other major legal areas that you want to bring up? I know we've got a limited time, but is there anything else that you'd like to address?
I think, if you implement new screening protocols for your employees upon returning to work, please just make sure you are complying with HIPAA. It's not a bad idea to have one specific HR person in place, although it's not required. And just a piece of advice I guess I would give to employers, Make sure that all decisions relating to bringing your employees back are neutral and job related and not based on protected characteristics. Because, you know, when the stay-at-home order went into effect, so many of our businesses turned around and said, okay, all my employees over the age of 60 need to go home now. And that is an age discrimination lawsuit. You know, obviously they're doing it for the care of their employees, but on the face of it, if you're only sending your employees over the age of 60 home, you know, that's age discrimination. And so just anything that you're doing, make sure that it's neutral and job related, and you're not making decisions based on someone's medical status either.
So, you know, I would urge you all to just keep your employees, your customers, and those that come to your facilities safe, and do your best to protect them. This is a really fluid situation. None of us have ever been through anything like this. So being aware of what's going on, good resources. Again, I believe that the CDC, OSHA, Cal OSHA are great resources, and things are changing quickly and often. So do your best to keep in touch with the individuals that you have a relationship with in the various arenas that you're exposed to. And anything to wrap up, Cindy?
You know, just one thing is I created this Reopening Your Business playbook. I'm happy to email it to anyone who wants it. In that playbook, you know, it's a step-by-step guide. There are clickable links throughout, but at the end of it, I created a welcome back letter. So it's a sample template that you can use to welcome your employees back to work. And then the second addendum in that playbook is an attachment that you can use on the back of your employee handbook. So it's an addendum to your employee handbook, and it allows you to give out to your employees about all things that you want to consider that COVID related without having to redo your entire handbook. So if anybody wants that, I'm more than happy to send it to them. And Geoff, I think you have something too, right?
Yes, if any of you are interested in a return to work action playbook, let me know. We can forward that to you also. And again, it's a template that you can edit and apply to your own location. I'd like to thank you all. If there are any other questions, feel free to let us know.
Yeah, anyone can, you know, email either myself or Geoff. Geoff, do you want to say what your email address is?
Yes, I am Geoff, Geoff, Johansing, Johansing, at IOAUSA.com. And Cindy, you?
Perfect. My email address is Cindy, CINDY, at hacklerflynnlaw.com. And that's HACKLERFLYNN law.com.
Well, thank you, everyone. This, again, has been recorded. If you would like to share a recording, feel free to reach out to us and let us know. Thank you, everyone.
Absolutely.
Have a great day.
All right, thanks.